All right, good morning. We're on the record in the 89th District Court for the County of Sheboygan. We're here in the matter of contempt of Beth Bridgeman. It was committed and filed under the case of People v. Seth Flores, filed 23-0868 SD. Counsel, you want to state your appearance for the record, please?
Melissa Goodrich, Sheboygan County Prosecutor.
All right, Ms. Bridgeman is not present in the courtroom. Have we confirmed she's not out in the hallway? Okay, she's not out in the hallway. Ms. Bridgeman was, the court issued a order to show cause why she should not be held in contempt for the unauthorized practice of law and also preventing defendant Flores from meeting with his attorney before his arraignment. I do see in the file a proof of service that she has been served with that, and in fact also in the file where Ms. Bridgeman has returned.
Wow, let's pause here. Already, this case feels unusual. Instead of showing up like everyone else, Beth literally shredded the court's order and wrote across it. Your offer to contract is not accepted. This is a classic sovereign citizen tactic, where people argue that legal proceedings are just contracts they can refuse. Judges, of course, see as defiance and contempt.
It's now 11:16. Ms. Bridgeman is still not present in the courtroom. Is she present in the hallway?
Not present.
Okay, she's not present. This appears to be a willful non-appearance due to the fact that she's returned the show cause affidavit and the order with it cut into pieces with the red lettering. Your offer to contract is not accepted. Of course, it's not an offer, it's an order of the court to show cause. She has now willfully not appeared. Ms. Goodrich, do the people have a request?
Your Honor, at this time, since we're here on a show cause, she's been properly served and also given an additional 15 minutes to appear. We would ask for a bench warrant to be issued.
Request as to bond?
No bond.
I think given the willfulness of the behavior, we'll set bond of arraignment. So I'll issue a warrant for Ms. Bridgeman's arrest for her contempt for non-appearance today.
Here's the turning point. The judge issues a no-bond bench warrant. That means she won't be walking out freely. Courts don't take kindly to people ignoring orders, especially when they've been formally served. This moment shows how fast contempt escalates, from paper games to jail time.
Appearing as arraignment attorney on behalf of Beth Bridgeman.
Also, I will represent myself.
Yes,
Okay.
we'll get to that.
I would like to say I'm here on special appearance. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
Ma'am, you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So
but
I am
now's
waiving
not the time.
I am not waiving any of my rights.
Ma'am. Okay. Thank you.
Ms. Bridgeman, you're free to stand or sit, whichever you're more comfortable.
I don't know how I would pull a chair up, so thank you.
Well, then, if you want to sit there, I have no problem. All right, well, Ms. Bridgeman, you're here for an arraignment on 2 allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for
That special appearance argument you just heard, another sovereign idea. She claims she's a living soul and not the strawman tied to her legal name. Judges hear this over and over, but it never works. What's striking is how calmly the judge handles it. Even though most people watching are probably thinking, what is she even talking about?
We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it. Says your offer to contract is not accepted, and then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So,
Failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the 2 contempt citations pending against you. You have the right to have a hearing on both of those allegations, where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you. You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a
What is
statute.
MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know, well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and or a fine of $7,500 or both. That's the fine, that's the maximum penalty for both of the contempt citations. Ms. Bridgeman?
The judge explains her 2 contempt charges clearly: unauthorized practice of law and failure to appear. Maximum penalty: up to 93 days in jail and a $7,500 fine each. Notice how patient he is. He's giving her every opportunity to understand her rights. But instead of listening, she shifts back to technicalities and conspiracies.
A copy of it. He can't serve a show cause because you're not under bond. This is from the State Attorney General's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me for you.
Ma'am,
Now,
just understand what the judge asked you regarding those 2 charges.
Did you just understand that I think there's a bigger overriding issue? Thank you.
Hang on.
Thank
I'm
you.
not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any of
No,
that.
because you already,
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between
Thank
you
you.
and Ms. Bridgeman.
I guess I just like to, state that
well, I think we need
she's
to back it up.
pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future
Okay.
hearing.
No,
Your
but
Honor, I
all
just
of my
want to-
rights were strongly impinged upon for even when I never failed to appear.
We're going to have a hearing where you.
She
can
was
present
working-
that. Mr. Villanueva,
No,
I'm
this
directing you to
is-
stop
Thank you.
arguing with Ms. Bridgeman.
Okay.
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else. When I was not being belligerent in that regard, she told me that it was not an.
This is where it gets frustrating. She insists the Attorney General's office told her the judge couldn't issue the order. Whether true or not, that's not how courtrooms work. You don't just ignore an order because someone on the phone told you it might not apply. You still show up, then argue it properly.
Context of everything today, Judge Gaffier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
What did not offend me? It was a contempt of court.
It's a
It's
common law
not about
thing.
anybody's personal feelings. It's about the authority of the court to compel appearances, and you did not appear. So I do believe, based upon your answers, that you do.
The judge sums it up perfectly. Contempt isn't about feelings. It's about obeying the authority of the court. When you cut up an order and refuse to appear, that's contempt, plain and simple. At this point, he's losing patience, but still keeping it professional.
That you wish to plead not guilty to those charges of contempt. I gather from your comments that you would agree that you're not pleading guilty to those, correct? Okay. All right, so we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charged. I can read it again if you want.
I don't see where there's a code or a statute or any law that I have actually violated here.
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will.
Okay, and the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now.
This exchange shows how far apart the judge and the defendant really are. Because Beth refuses to enter a plea, the judge does it for her, a standard procedure to keep the case moving. Then she demands a jury trial, thinking that will give her more control. But contempt doesn't work that way. It's not a matter for 12 citizens to debate. It's about whether someone directly defied the authority of the court.
Date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees than you do,
All right,
okay?
all right.
Now,
I'm going to find that
what please, Judge Gothier.
sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
It was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would you generally like to see what she has
But-
here?
I just, so
Okay,
you don't.
so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy.
This is the moment where the hearing shifts from legal argument to personal attack. Instead of addressing the contempt charges, Beth claims she probably has more degrees than the judge. It's a striking line, but also a revealing one. In court, education doesn't override authority. You can hold 10 diplomas. But if you ignore a judge's order, the law will still hold you accountable.
Not yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond before the next hearing. So I'm going to hear first from the prosecutor and then from you on that question. Ms. Miller?
Your Honor, I would object to a PR bond in this case first because of her failure to appear on December 20th. She had notice of that hearing date as she dropped off the show cause to the court that had that date on it. Further, an underlying case that this was initially filed, she encouraged someone to not appear for their court date or to leave the court before they were arraigned. So I do have a concern about her appearance at the next.
All right, Ms. Bridgeman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether...
I showed up at 9 a.m., Your Honor, and anybody could have called me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court? That's the arcing question here, I think. And I think a lot of people
Well, I can
struggle with
recommend the
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
Oh, I know how it happens.
Your Honor.
I also know we don't have a lot of
Your Honor.
judicial review.
So,
Your Honor, part
as the
of
bond
the-
question, any input, Mr. Gilman?
Yes, I guess, I know you just released me as the attorney of record, but I guess in support of the bond on her behalf.
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgeman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability, so she informs me. I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgeman, and she reports that there's no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the Sheboygan County for that. And so I advise that Your Honor. Oh, and one last thing, she's a politically active member in the community. She has audited an election previously, so I believe she's more or less, I guess, committed to this area, this local municipality. It seems unlikely that she would go anywhere, and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgeman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut up the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they
It
didn't
wasn't an offer, it was an order
Sorry.
to appear.
They didn't
And you can't
actually
have
hand it
people
to
just
me.
refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety the full amount. There'll be no special conditions attached to it, however, just the standard conditions, Ms. Bridgeman, that you have to make sure that we know. If you change we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
So the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court.
And here's the climax. The judge sets her bond at $110,000 cash. That's huge. Why? Because she's not seen as a flight risk, but as someone likely to simply refuse to show up again. To the judge, her words and actions prove she won't take the process seriously. In the end, this case highlights a painful truth. The law doesn't bend to sovereign beliefs, no matter how passionately argued.